Hello landlords, it's Ernie again. I'm here to talk to you today about another Texas statute that every landlord should know. Let's get started. Welcome to my YouTube channel. I've been helping clients for over a decade, and now I'm coming straight to you. To get even more great videos, click our links to like and subscribe. Stay in touch by phone, text, email, or on our highly interactive Facebook group, Texas Landlords. And now, Ernie Talks. So today we're talking about security deposits. Namely, what to do at the end of a lease once a tenant has vacated the property. Now, we're going to cover one specific statute. Although a number of statutes in the Texas Property Code cover this topic, we're going to focus on Texas Property Code section 92.109. If you've been doing this long enough, you may have received a letter from a former tenant demanding either the entire deposit back or a portion of the deposit that you withheld. That demand may have featured some portion of section 92.109 in the demand, which is a very scary sounding statute because it has some significant teeth in it. Essentially, the statute awards a tenant a potential judgment for 3 times the wrongfully withheld deposit amount plus $100 plus all of their reasonable and necessary attorney fees and court costs. So let's assume that there was a $2,000 deposit and you kept back $1,500 of it and you sent a check for $500 to your former tenant. Well, you may receive this demand letter from them asking for well over $5,000. And in your mind, you're thinking, I don't understand. The deposit was only $2,000. But they've added these multiplied security deposit amounts plus attorney fees and court costs and then the $100. I'm going to explain how this works, and when you're faced with a demand like this, you'll know how to respond. So we're going to break this statute down into 3 basic parts. The first part has to do with the damage calculation. Now, I've already explained to you that the landlord could be subject to as many as 3 times the deposit amount and all the reasonable and necessary attorney fees along with court costs and that $100 statutory damage amount. These amounts, however, are only applicable if the tenant can establish bad faith on the part of the landlord. Next, the statute describes the need for the landlord to have submitted to the tenant an itemized list. This list is a description of all of the damages that the landlord uses as the basis for withholding any amount of the security deposit on file for this tenant. Whenever a landlord fails to deliver this list on time or at all, the landlord then forfeits any ability to charge against the security deposit any of the damages that a landlord may later claim. Additionally, if the landlord fails to deliver this itemized list according to the statute, the landlord waives its right to later sue a defendant to recover any of these damages. Finally, the statute addresses the issue of bad faith on the part of the landlord. In this particular section of the statute, it explains that the burden actually shifts to the landlord. A landlord then has to prove that the portion of the deposit that was withheld in good faith. A landlord who fails to deliver this notice, this itemized list of damages to their tenant within 30 days of the tenant vacating the property is presumed to have acted in bad faith. The tenant doesn't even have to prove this fact. The court presumes it strictly on the basis that the itemized list was not delivered to the tenant. So how does a landlord protect themselves in this event? Well, first and foremost, the best thing to do is to prepare an itemized list well ahead of time. While the property code allows you to wait to as many as 30 days, my suggestion is always to send the notice within 2 weeks of recovering possession. This way, you can get beyond any claim that the statute requires that the notice be received within those 30 days. Generally speaking, if you put something in the mail, you can account for 3 to 5 days, 10 days in exigent circumstances, but certainly 2 weeks should be enough time to deliver that itemized list to your tenant through the regular mail. Now, along with delivering this notice by the mail, we suggest that you send it through every available avenue. If you can do it by text and email and US mail, you're recommended to do it. Now, the property code is going to hold you to the notice provisions in your lease, but naturally, if you go beyond what's expected in your lease, it's all the better for you. So what do you do if a tenant has not given you a forwarding address? Well, you actually have a couple of options. First, the property code actually relieves the landlord of any burden of returning a deposit or that itemized list of damages to a tenant who fails to give a forwarding address. That doesn't mean that you get to withhold the deposit, though. At any time, the tenant can submit a forwarding address to you, and then your obligation to refund the deposit kicks in. Would it be fair to say then that once the tenant has vacated and later supplies a forwarding address, that at that point a 30-day time frame would begin to run? Absolutely. But my suggestion is still the same. Do your best to get that itemized list to the tenant sooner rather than later. All of this works in your favor in establishing your good faith in addressing the tenant's security deposit. One thing you could attempt to do is to mail the itemized list to the property itself. If the tenant has taken care of forwarding their mail, they should receive the notice even if they haven't given you a proper forwarding address. Additionally, if they have provided you with a fax or a text number or an email address, you can continue to notify them through these means, even if these are not available in the notice provision of your residential lease. So what you cannot do is charge for repairs that come from ordinary wear and tear or ordinary use. That's an absolute no. Let me give you the classic example. The tenant moves into the unit and the carpet that's in there is not brand new, but it's also not super old. Let's assume 3 years. And the tenant stays for 5 years. The tenant leaves. What can you do about the carpet? Well, generally speaking, after 8 years, carpet has virtually no value. So you cannot re-carpet the entire unit and deduct that amount from the deposit. If the carpet is used up after 8 years through normal use, you simply can't charge that against the deposit. However, let's look at a similar scenario where brand new carpet is put down and a tenant only stays for 6 months. After the tenant vacates, you notice that the carpet is completely ruined. There are stains and wear marks, maybe a pet tore up bits and pieces of the carpet, and you have to replace the entire carpet after 6 months. You might have a pretty good, very reasonable basis for withholding portions of the deposit based on non-normal use and non-normal wear and tear of the carpet in this situation. Essentially, what you have to use is a reasonable person basis for determination of whether or not something was replaced by defect of normal and ordinary use, or whether it goes beyond that. If yours is on the fence, you may want to consider simply refunding the money, particularly for something that you know was already used or had some miles on it before the tenant took it. You certainly don't want to haggle over small things and be hauled into court over $50 or $100. It simply isn't worth the time, particularly if the burden shifts to you. Another situation to consider is, what if when the tenant leaves, they owed rent? Well, this is a common thing. The tenant leaves, owes a balance in unpaid rent, and then makes a demand for their security deposit. I've seen it happen all the time. I've seen it happen in eviction proceedings. What do? Normally, the Texas Property Code assumes that a refund is going to happen. There is a presumption that the entire security deposit is going to be refunded to the tenant. However, that presumption can be overcome with the facts. The Texas Property Code goes on to say that in the event that a tenant vacates, leaving rent unpaid, the landlord is not even required to submit that itemized list of damages. But a couple of provisions have to apply. Number one, it has to be understood that rent went unpaid, and there has to be no controversy as to the amount of rent due. That issue pops up from time to time if the tenant exercised some other statutory or contractual rights. We're not going to get into that. Here's a very simple way of looking at it. Let's assume again that deposit of $2,000, and let's assume that the rent is $2,000 a month. Let's also assume that when the tenant vacates, there were 2 months of unpaid rent. The last month the tenant was there, and the prior month went completely unpaid, and the tenant left. They left you a forwarding address, but they had not paid for 2 months for which the tenants had actually occupied the unit. Well, if $2,000 is held in deposit, in that case, you would have no legal obligation to send an itemized listing of damages, which you may have, and there would be no need to wait for a forwarding address or to address the issue at all. However, it is still my recommendation that anytime you are holding a deposit and you, even with a right to apply to damages or unpaid rent, that you send an itemized list deducting from the security deposit all of the valid deductions you have. The property code gives you a way out of this obligation. I'm telling you, you're better off going above and beyond what your lease requires and what the property code requires, because nothing erases a presumption of bad faith like good faith. And so when you're dealing with tenants, you should always presume that when they leave you, it's not the last time you're going to see them unless you have properly closed the door on as many claims as you possibly can. In this case, when you're thinking about the deposit and what to do with it, always consider that 92.109 is out there. And the Texas Property Code makes certain presumptions that are very favorable to the tenant. However, you can overcome those presumptions by acting always in the interest of prepping your case for trial before that case is ever presented. Always assume you're going to send an itemized list of damages. Always presume that even if you're not given a forwarding address, that you can mail the notice to the unit, the rental unit, and hopefully it eventually makes it to the tenant. And then even if a tenant leaves having owed rent, even rent in excess of the security deposit, it's always a good idea to mention that in your itemized list. List it all. Be meticulous about everything that you mention. And it's always a good idea to go beyond the amount of the deposit, especially if you plan to keep the entire deposit, even if, again, multiple months are owed in unpaid rent. List everything. You don't want a tenant who later tries to make a claim and you measured everything to the penny of the deposit and then stopped because you were busy, and then they call you on something that they're able to convince a court is a charge that is inapplicable. If that's your case, you want to make sure that you've got 3 or 4 other reasons why no deposit should be issued. As always, one of the biggest ways to prevent these kinds of issues is to properly mention all the things that can be deducted from a security deposit in your lease. Your lease is your first weapon in this defense. Your lease should explain that your security deposit can be used for all sorts of things, especially if the tenant is in default. I will be delivering additional videos having to do with various statutes in the Texas Property Code, but until next time, happy leasing. If you enjoyed this video, we invite you to like and subscribe. Follow our links to even more great content. We're always adding to this collection. If you have a video topic you'd like to see, comment below.